Debo Adegbile has a keen intellect, life experience, and knowledge sufficient to be an excellent Assistant Attorney General. What an American story we find in his life. The son of Nigerian and Irish immigrants worked his way up from poverty, including periods of homelessness and reliance on welfare, to the top of the legal profession. Graduated from Connecticut College, NYU Law School, spent the early years of his career at one of the most highly regarded law firms in New York. Then he decided to start working at the NAACP Legal Defense Fund, ultimately becoming the organization's acting president and director counsel. For those who don't know the NAACP Legal Defense Fund, I would commend to them a book, The Devil in the Grove. It is a Pulitzer Prize-winning story of the work of Thurgood Marshall in the 1940s and 50s, when the NAACP Legal Defense Fund was literally the only voice for those who were poor and black in America. Time and again, Thurgood Marshall would journey to parts of America and risk his life to defend someone accused of crime. They were the only ones who would stand up and speak for the poor and those who were in minority status. Well, Mr. Adegbile joined the NAACP Legal Defense Fund, and during his 20-year career, he's gained experience and perspective on a wide range of issues, certainly qualifying for him for this job with the Civil Rights Division. He has widespread, enthusiastic support from a broad spectrum of civil rights groups, law enforcement organizations, police officers, prosecutors, business leaders, government officials, and prominent members of both political parties. He has twice been called on to defend the constitutionality of the Voting Rights Act in oral arguments before the United States Supreme Court. In the year 2013, he was the only African-American attorney to argue before the Supreme Court. There is no question about his competence. He led the NAACP Legal Defense and Education Fund's legislative outreach and public education efforts on the Voting Rights Reauthorization Act in 2006, which was passed by a unanimous 98-0 vote in the Senate, 390 to 33 in the House. He's represented minorities in case after case involving employment discrimination. He led the efforts to repeal Proposition 36 initiative, California's overly punitive three strikes law, and it passed with 70% the vote of Californians. While he was in private practice, he successfully represented pro bono clients. His is an extraordinary legal resume. As these select career highlights demonstrate, he's an effective advocate who could lead this Civil Rights Division. Don't take my word for it, though. The Bush administration Solicitor General Paul Clement stated, and I quote, "I've litigated both with and against Debo and have heard him argue in the Supreme Court. I have always found him to be a formidable advocate of the highest intellect, skills, and integrity." Mr. Adegbile's representation of Mumia Abu-Jamal does not mean that he lacks respect for the rule of law, and it certainly should not disqualify him for this important civil rights job. In fact, his willingness to represent an unpopular defendant in an emotionally charged case demonstrates his appreciation for the rule of law, as well as his respect for the criminal justice system. His critics have attempted to characterize him as someone who actively sought out this case, someone who disparaged the officer who was cut down in the line of duty, Officer Faulkner, and someone who was responsible for Abu Jamal's death sentence being overturned. Each of these characterizations is wrong, inaccurate, and unfair. The NAACP Legal Defense Fund was not involved in the Abu Jamal case until 2006, nearly 25 years after the trial of this individual and his conviction, and 5 years after the death sentence was overturned, being converted to life prison. LDF's president, not Mr. Adegbile, made the decision for the organization to be involved in the case. Moreover, as Adegbile stated before the committee, the briefs he signed made no negative comments whatsoever about the tragic loss of Officer Faulkner. I see the chairman of the committee is here, and I know our time is short. And let me just say this. Time and again in the history of the United States, people have stood up understanding the Constitution and the responsibility of the bar to represent unpopular defendants. John Adams set the standard. when he made the unpopular decision to represent British soldiers on the eve of the Revolutionary War. The Senate recalled that example in 2003 when it confirmed John Roberts to the D.C. Circuit. At the time, not one single senator raised a concern about then-Judge Roberts providing pro bono representation to a man who had been convicted of killing 8 people and was awaiting execution on Florida's death row. What John Roberts did, now Chief Justice of the Supreme Court, was entirely consistent with our Constitution and the responsibility of those of us in the legal profession. I would say at this point, we have an extraordinary man with an extraordinary background who has offered his services to this government in an important division where he can serve in a capacity that few can match. The full scope of his life experience and his distinguished record make him well qualified, and I will support his nomination.